The Supreme Court on Thursday delivered a split verdict on the Karnataka government's order of restricting wearing of hijab inside classrooms in pre-university colleges. The split judgment was announced by a bench of judges consisting of Hemant Gupta and Sudhanshu Dhulia. Justice Hemant Gupta dismissed the appeals against the Karnataka High Court judgment. On the other hand, Justice Sudhanshu Dhulia allowed all the appeals and set aside the judgment of the Karnataka High Court. A lawyer representing the petitioner said that the case will be placed before the Chief Justice of India and it is up to him to decide whether a new bench will hear the matter or a larger bench will hear the matter. The hijab row came into light when the government NLTV college in Udupi, Karnataka allegedly barred 6 girls wearing hijab from entering. As a result, Karnataka government, while banning the hijab and saffron scarves, stated that students must adhere to the uniform only till an expert committee decides on the issue. Notably, Karnataka High Court on 15 March 2022 held that hijab is not an essential religious practice in Islam.
Two judges with divergent approaches. When the judges sat only, they said we have taken divergent views. Justice Gupta, who was the senior and the presiding judge, straight away said that. Then he read out his 11 questions which he had framed in his judgment, and he said each of those 11 questions he has decided against the petitioners. And thereafter, Justice Dhulia effectively read out, or whatever, he didn't read out, but effectively, told the court as to what his reasons were. And he said that what has weighed with him was the fact that girl education in this country is still a challenge, and a restriction such as this will only further that challenge. Therefore, to facilitate girl education, one needs to be accommodative. And he said that the right of a girl to wear headscarf when she is otherwise wearing the rest of the uniform is protected under Article 25(1) and 19(1)(a). And he pointed out that the whole approach of the High Court in going down the essential religious practice route to determine was possibly not correct, because that was not necessary to decide whether this was essential religious practice or not. And on principles of constitution independent of the essential religious practice, this is a matter which needed to be decided, and that's the way he has gone. So, two judges with divergent approaches. When the judges sat only, they said we have taken divergent views. Justice Gupta, who was the senior and the presiding judge, straight away said that. Then he read out his 11 questions which he had framed in his judgment, and he said each of those 11 questions he has decided against the petitioners. And thereafter,
Nagaland TV, Soap Manulaga Awas. Watch us live on Geo TV and on your television sets as well. For Dimapur viewers, we are on channel number 994 in Global Chapter, and Kohima and Mokokchung viewers, switch to channel number 138 on Hornbill Digital. For all news and updates, follow us on Facebook, Instagram, YouTube and Twitter.